behalf of Yousaf and Davies and filed in London Borough of Islington.
Yes, Mr. Carpenter.
May it please your lordship, your ladyships. This is the hearing of two appeals,
Yes.
which both relate to the treatment of claims for credit hire charges under the pre-action protocol for low-value personal injury claims in road traffic accidents, which I will...
Excuse me a minute, just close the door. We're
Yes.
rather short-staffed today.
Understandably so.
Thank you. Right.
My lord, subject to the court's approval, the parties to the two appeals have agreed that Yousaf and Davies, in which I appear, should be heard first, with
Yes.
the London Borough of Islington and Bourous to follow. In Yousaf, I appear for the appellant with my learned friend, Mr. Fardy. The respondent is represented by Mr. Williams, Queen's Counsel, and Mr. Eastwood.
Yes.
And in the other case, the appellant is represented by Mr. Bright, and the respondent by my learned friend, Mr. Campbell.
Yes. Thank you.
My lord, my ladies, the particular issues raised by Yousaf are the evidential standard to be applied to claims of impecuniosity and the circumstances in which a contested claim should leave the protocol to be dealt with under Part 7,
Yes.
outside the protocol. And as the court will have appreciated, the amount actually at stake on this particular case is very small, but we are here because there are very many claims like it,
Yes.
and there is the potential for very large sums to be in issue.
Well, plainly, we need to be taken, probably by you, because you're first on your feet, through the protocol in some detail, rather than just focusing on the narrow points that might be relevant to your particular case or to the other case, because we're conscious that what we may say may influence a wide range of cases. So please feel free to educate us as widely as you think we ought to be educated.
My lord, I will certainly attempt to do that, and I'm sure it's obvious that the parties seek not only resolution of the particular case before the court, but more general guidance to
Yes.
the industry on the issues that it raises. So, my lord, in terms of the structure of my submissions, what I propose to do is address the substantive legal framework, first of all, and then take the court through the protocol, then address what we say the correct approach should be to the issues that our case raises, and then finally to look at what actually happened in this case and what we submit the outcome of this appeal should be. There is, as the court will have seen, an issue raised by the respondent in our case as to whether we require the permission of the court to pursue this appeal, notwithstanding that Lord Justice Bean, of course, granted permission to appeal on both grounds. We do submit that there's no merit in that point, but in terms of the order of events, I propose to deal with that at the end when I'm addressing the circumstances of this particular case, if that is convenient to the court.
Well, Mr. Williams, is that acceptable to you?
Yeah, forgive me. Yes, it's perfectly acceptable for my own offence to deal with matters in that way. We do take the point,
Yes.
But we recognise that irrespective of that point, this is a second appeal. Two second appeals, we're all here. As Mr. Carpenter says, there are matters of wider interest to the profession, and we're not necessarily expecting that even if your lordship is with us on the points, nevertheless the judgment won't address some other things as well.
I think that I and my ladies have discussed it just in outline, and that was the thrust of our thinking before hearing either of you, that we owe it to the case, the wider point, to hear full argument, but reserving the point you make, which on the particular appeal may or may not be important.
Thank you, my lord.
Yeah.
My lord, I'm grateful for that indication. So, turning then to the substantive law, much of what I'm going to say is not in dispute, and so with one exception, unless your lordship or your ladyships wish me to do so, I don't propose to go to the underlying cases, though they are all in the authorities bundle. The issue of impecuniosity potentially arises whenever a claim is made for credit hire charges, and I expect the court is familiar with the concept of credit hire, but in very brief outline, a company will provide a replacement vehicle to a claimant driver who is assumed to be the innocent party in a road traffic accident at no upfront cost to them, on the basis that the charges will be recovered from the defendant in the proceedings and otherwise waived. And that is invariably more expensive than going to your local branch of Hertz or Avis and paying over the counter for a replacement vehicle. And the issue of impecuniosity can arise in three ways. What they have in common is that they all raise the question of whether the claimant has reasonably mitigated loss caused by the vehicle, their ordinary vehicle, being off the road. The most common way in which it arises, though that is not actually the way that is germane to the particular facts of our case, but the most common way in which it will arise is simply because the credit hire charges exceed what is referred to as the basic hire rate, which is the over-the-counter rate. And in some of the earlier authorities, you will see it referred to as the spot rate, but that terminology was disapproved of in one of the cases decided in this court, so we call it now the basic hire rate, or BHR.
And if I've understood it correctly, that's likely to be the case in virtually every circumstance, because the credit hire is a more expensive way of achieving what you want.
My lord, it will, and it will almost certainly be the case that credit hire is more expensive because you are paying for benefits that you don't get if you're hiring a car outright, not least the risk to the hirer that no one will ever pay for it, and the fact that the hire is, as it suggests, on credit. There are very rare exceptional cases, such as, for example, the Darren Bent case, which came to this court, where the hiring of a particularly high-performance vehicle at credit hire rates turned out to have been no more expensive than the over-the-counter rates. But in the general run of things, it is a reasonable assumption that the credit hire rate will be more, and perhaps significantly more, than the basic hire rate. And the principle that an impecunious claimant can recover the credit hire rate and is not limited to the basic hire rate was established by the House of Lords in Lagden and O'Connor. And that's the case that consigned the Liesbosch to legal history. And at least, as expressed by Lord Nichols in that case, an impecunious claimant was one who was not in a position to pay the basic hire rate without unreasonable sacrifice. So that is the first way in which it can arise. And as my lord says, in principle it arises in every case, but it can also arise in other ways. The second way it may arise is in relation to the question of duration. So the claimant may have hired a vehicle for longer than they might otherwise have needed to do because they could not afford to repair or replace their ordinary vehicle. And then the third way it may arise, which is particularly germane to our case, is that if the vehicle is a profit-earning chattel, in other words, if the claimant is a professional driver, such as a taxi driver, and cannot work without the vehicle, then the ordinary measure of loss in that situation is going to be the lost profit while the vehicle is out of use. And if the claimant hires an alternative vehicle so that they can keep working, and the cost of the hire is greater than the income that they would otherwise forego, then prima facie they have failed to mitigate their loss. But that may nevertheless have been a reasonable thing to do if, for example, the claimant just cannot afford not to be working during the period while their vehicle is off the road, and therefore that raises the question of impecuniosity. And the leading authority on that, which I will take the court to because it is central to the issues in our case, is Hussein and EUI Limited, which is in the authorities bundle at tab 9.
Yes.
And this was a case involving a claim for credit hire by a self-employed taxi driver. He had hired a vehicle at a cost of almost £6,600 to avoid lost profit of £423. What the case actually turned on was whether it was open at trial to the claimant to adduce evidence of his impecuniosity, and it had been held that he hadn't been, and that had been upheld. So the outcome was that he was limited to his claim for lost profit. But relevantly for our purposes, we see the principles set out at page 160 of the bundle, and paragraphs 16 and 17 of the judgment. And 16 is very long, and I don't propose even actually to invite the court to read that paragraph now, but for these purposes simply to note it. As can be seen, these are not new principles. These are principles derived from, in some cases, authority of long standing. What we see the learned judge in that case, Mr. Justice Pepperell, concluding at 16.5 is that if essentially the cost of hire is at the level of the profits of recouped or thereabouts, then the court is not going to count the pennies. But, and we see at B, where the cost of hire significantly exceeds the avoided loss of profit, the court will ordinarily limit damages to the lost profit. And then we see at 16.6 over the page 3 circumstances in which a claimant may act reasonably in nevertheless incurring the higher charges. And the one that is relevant for these purposes is C. It might be reasonable for a professional driver to hire a replacement vehicle, even though the cost of doing so was significantly more than the loss of profit, because he simply could not afford not to work. The tortfeasor takes his victim as he finds him, and impecunious self-employed claimants cannot be expected to be left without any income and forced to look to the state to provide for their families on the basis that they might eventually recover their loss of profit some months or years later. And then the judge went on in the next paragraph to note that this essentially raises the same issue as is raised in what might be called the ordinary case, following Lagden and O'Connor. And then importantly, picking it up in the middle of that paragraph, any claimant wishing to justify higher costs on this basis will therefore have to comply with the directions given by the court in respect of the disclosure of documents as to his or her income, outgoings, assets, liabilities, and access to credit. Even where the claimant's income is low, the court will not simply accept an assertion that he or she could not afford not to work without proper evidence of impecuniosity. And that, I submit, is a very important dictum in respect of what the result we say should have been in this case.
Yeah, the wording seems to apply to ordinary contested civil proceedings, and not necessarily to the different process under the protocol. But you'll develop that. But
of course, my lord, that is right, and I have to convince the court that the standards which are undoubtedly expected outside the protocol should be applied within it, and I will come on to that and, of course, address that. It is now well established that the burden of proof in establishing impecuniosity in all circumstances is on the claimant. My learned friend's skeleton argument in response to ours appears to raise a further issue as to whether the obligation to demonstrate impecuniosity arises before the defendant has shown that the basic hire rate is less than the credit hire rate. Now, that doesn't arise directly in this case because we don't approach this as a credit hire versus basic hire rate case. We approach this purely as a Hussein case. And impecuniosity was clearly in issue by the stage 3 hearing in this case. But it arises indirectly as part of the argument on how the court should approach the issue of impecuniosity in protocol cases. So it may be convenient to address that now. And in summary, what I submit the authorities show is that in both basic hire rate cases and in Hussein-type cases, the question of impecuniosity is prior to the question of what the basic hire rate is. And the obligation is on the claimant to plead and prove impecuniosity in a credit hire claim from the outset. And addressing that point will require me to take the court on something of a tour of the authorities that my learned friend points to in support of his contrary argument. And he takes as his starting point, which I think is probably the best place to start, an observation of Lord Hope in Lagden. And your lordships will find that, your ladyships will find that behind tab 1 in the authorities bundle at page 14. And your Lordship will see there a highlighted passage in paragraph 34. That is the passage that the respondent relies on this case. I don't propose to read it out. The court may wish just to consider that. But there are two sentences, I think, in particular, that Milena Friend placed particular reliance on. It is for the defendant who seeks a deduction from expenditure and mitigation on the ground of betterment to make out his case for doing so. And then, moving on one sentence, it has to be shown that the claimant had a choice and that he would have been able to mitigate his loss at less cost. I think that is what Milena Friend places reliance on in saying, well, it's essentially for the defendant to go first. What I say, my lord, my ladies, about that observation is, first of all, Lord Hope was in the majority in this case, but his speech is not that of the majority. Only Lord Nichols's speech was concurred in by Lord Slynn, so insofar as there is a majority speech in this case, it is that of Lord Nichols. That is not simply to sideline, of course, what Lord Hope said, but it's important to note that the court was simply not concerned with this particular issue. The question of who goes first or in what order things happen was not material at all to the decision in Langton. That was simply about the principle, can an impecunious claimant ever recover the credit hire charges? The particular issue of the order of events has, however, been the subject of two decisions in this court. And while I accept that both are strictly obiter, they are consistent and, in my respectful submission, ought to be followed. The first of those is Patney, which is at tab 4 in the authorities bundle. This was two credit hire cases being heard together. No issue as to impecuniosity arose in either case. That is important to note. And we see that set out in paragraphs 2 and 3. Paragraph 2 in respect of the Patney appeal and paragraph 3 in respect of the Bent appeal. The particular passage that Milena Friend relies on appears in paragraph 35 at page 69.
Yeah.
And you will see the highlighted passage there. As a statement by itself, we of course take no issue with that. It's simply a statement of where the burden lies to prove what the BHR are. But it says nothing by itself about at what stage in the process that inquiry should be embarked upon. And actually, elsewhere in the same case, Lord Justice Aikens actually said the opposite of what the respondent would seek to show, and that's in paragraph 73 at page 78 of the bundle. And we see set out in the second half of paragraph 73 essentially a structured decision-making exercise. So he says, to summarise, the questions are, 1, did the claimant need to hire a replacement car at all? If so, 2, was it reasonable in all the circumstances to hire the particular type of car actually hired at the rate agreed? If it was, 3, was the claimant impecunious? And then, if not, 4, has the defendant proved a difference between the credit hire rate and the BHR? Paraphrasing. And then 5, what is that difference? So in terms of the logical order in which to approach the questions, the question of impecuniosity precedes that of whether there is a difference. Now, of course, in the real world, if the defendant has not evidenced a lower BHR than the credit hire rate, then of course the question of impecuniosity is moot. But in terms of the order in which those questions should be approached, it's clear from that in my submission that impecuniosity comes first.
And this again is not a protocol
case. I don't believe so, my lady. I believe that these were both cases which were never in the protocol at any stage. I'll be correct if I'm wrong about that.
They were back before 2010.
It's 2011.
Yes, of course. So they couldn't have been.
Yeah, the accidents were in the 2000s.
Yes. Yeah. But of course, these are the cases, it should also be said, that Milena Friend relies on to make his contrary point. So in terms of whether cases are inside or outside the protocol, that doesn't appear to be a distinction that Milena Friend makes for these purposes. The next case, I think, to show the court is behind the following tab in the authorities bundle, Zurich Insurance and Umergi. And this addresses the question of what the obligation is on a claimant. Now, this is a case that began in the protocol, but it left it. One of the very striking features of this case, and we'll come on to it when we look at the terms of the protocol, is that the claim for hire charges was over £95,000, and yet it could have been dealt with within the protocol. In fact, for a reason which isn't specified in the judgment, it left it. And so the question of quantum was dealt with in the ordinary Part 7 civil litigation environment. But it began as a protocol claim. And the statements of principle that I rely on for these purposes are, first of all, at paragraph 12 on page 89. And I accept that this is operative because it is not what the case turned on. But you'll see that at paragraph 12, the court was taken to parts of Practice Direction 16. And then in the last 3 lines, I mention this because the appellants took the point later that the claimant should have pleaded his impecuniosity in the particulars of claim, but that is academic since, as will appear, the issue is addressed squarely at a later stage. And then there is a footnote which addresses what is something of a controversial question of whether there is a general obligation on a claimant to plead, as the civil procedure rules appear to require them to do, facts relevant to mitigation before the defendants actually put the question of mitigation in issue. But in this particular case, the court was clear that the obligation is there from the start, and it's the last 3 lines of that footnote. The position is different in the case of a claim for expenditure reasonably incurred in mitigation of the primary loss. In such a case, the claimant should plead his case as to reasonableness, including any assertion of impecuniosity. See paragraph 37 below. And so if we then go on to paragraph 37, that is at page 98, going over to 99, that is a fairly lengthy paragraph, but what's said in it is quite important. Perhaps I could just invite the court to read that paragraph.
Yes.
So, my lord, that's the position in that case, and that has recently been reinforced by another decision of this court, Dirier and Boyai, which is at tab 10 of the bundle, and in which I note my Lady Justice Nicola Davies was a member of the court. And this again, like some of the other cases, was a case where, because of procedural failures, the claimant had got himself in a position where by the final hearing he was debarred from adducing evidence of his impecuniosity or pursuing that issue. And the case was essentially a decision on relief from sanctions. But in the course of his judgment, Lord Justice Coulson made observations on the 2 issues germane to this case of the obligation on a claimant to plead and prove impecuniosity from the outset, but also what is required to support a plea of impecuniosity in terms of detail and data. And we can pick this up, first of all, I think, at paragraph 4 at page 164 of the bundle, where, if I can just paraphrase, Lord Justice Coulson referred to Langton and O'Connor and referred to the passages in Zurich that we have just looked at. Then at paragraph 7 on the following page, Lord Justice Coulson said, in my view, 4 lines into that paragraph, the appellant ought to have provided the necessary pleading in respect of impecuniosity at the outset of the proceedings, so that in the absence of that information, the unless order was entirely proper. If, as Mr. Peter indicated, such orders are not uncommon, then that can only be because claimants in these sorts of cases are taking too lax an approach to the obligation to plead and prove impecuniosity so clearly spelt out in Zurich. That is a point to which I return below. We'll actually see in due course, when we look at them, that the standard directions in a case where impecuniosity is going to be an issue actually provide for an unless order to be made in every case as a first order, which is obviously unusual as a matter of case management, and indicates, we would say, the importance of claimants providing enough information for defendants to be able to form an informed view of where they stand on that issue. We can then, I think, go on to paragraph 48 at page 174. Paragraphs 48 and 49 have more to say about what is actually required of a plea of impecuniosity. Because what Lord Justice Coulson concluded was that not only had the unless order been breached because the reply that had been ordered had not been served on time, but in any case, it didn't set out, in quotes, all the facts relied on in support of the assertion of impecuniosity. So the Lord Justice noted that this was a claim by a minicab driver, and that was the source of his income. And he goes on, so the reply needed to set out what his income was and what his expenditure was, and how those figures meant that he could not afford to hire a replacement vehicle. Yet all the reply said on this topic was at paragraph 5, which stated simply that, as he earned cash as a minicab driver, he expended the same on bills and daily living allowances for his family. Nothing else of relevance was provided, no figures for income were pleaded at all. And then in the next paragraph, the Lord Justice referred to a witness statement, which he said did not improve the position served before the trial, where all he had said was, I had no money to repair or buy another car, and all my accounts were closed to their overdraft limits, and my credit cards had reached the maximum credit card limit. I have a bad credit rating as I have outstanding credit card bills, so I could not get a loan. The clear implication being that again, did not make up the deficiencies in the earlier pleading. If we then go on...
Sorry to interrupt, Mr. Collins.
Yes, I'm sorry, Millie.
This wasn't a case that was being dealt with in the RTA protocol, was it?
I don't believe so.
No, it
Paragraph
wasn't.
6.
Yeah, and
No.
if you look at paragraph 53, Lord Justice Coulson there refers to how civil litigation is supposed to work post-CPR. I suspect at this time he was Vice President of the Civil Division of this court as well, so had a particular interest in the CPR.
Yes, of course. The point should be made, however, and this is also relevant to understanding of Zurich, that if a case leaves the protocol, the proceedings that are then issued are ordinary Part 7 proceedings. So there will be the full panoply of pleadings and evidence and all the rest of it, even in a case which began in the protocol.
Sure, but this is a discussion of what happens once it's left the protocol and is in Part 7.
Yes, absolutely, my lady, of course. Yes, that's absolutely right. Yes, I mean, none of this applies directly within the protocol. There are no pleadings. I mean, this, of course, as we'll see, is precisely why the difficulties arise that have arisen in this case. Just to complete my submissions by reference to Dirier, on the next page from where we were looking at 175 at paragraph 53, there's, in my submission, another relevant observation that Mr. Peters' approach for the claimant ignored the respondent's position. They are entitled to know the case they have to meet. They should not be expected to have to prepare for a trial where the critical item of claim depends on a one-line assertion and hoping that as a result of the cross-examination of the appellant, the judge will reject the claim. That is not how civil litigation is supposed to work post-CPR. And then finally, paragraphs 66 and 67, if I may draw attention to those on page 177. And it may be convenient just to invite the court to read those two paragraphs. Sorry, which one? 66. Picking up the point, yes.
In my mind, in the protocol, is it assumed that every claimant will have a lawyer, or is it assumed that this will be a process used by litigants in person?
The protocol that we're concerned with, my lord, is for claims of a value which would otherwise fall within the fast track, and it's assumed that claimants will be legally represented, right. And the protocol provides for fixed costs.
On these two cases.
There is also, and its terms are also relevant to this appeal, and we'll look at it though in less detail, a newly, as of last May, introduced small claims protocol in which it's assumed that people won't be legally represented.
Thank you.
Now, picking up the point my lord made to me earlier, of course, this is to some extent a rather artificial argument because one can presume in perhaps 99% of the cases that the credit hire charges are going to exceed the basic hire rate. And any claimant, other than an exceptional case like Bent, ought to come into this knowing that they're going to have to prove impecuniosity if that's what they're going to rely on to justify claiming the credit hire charges. Just two more cases that are referred to by my learned friend, and so I need to take the court to very briefly. First of all, the case of Stevens, which is tab 6 of the authorities bundle, Stevens and Equity Syndicate Management Limited, another decision of this court. Although it's relied on by my learned friend, what I take from this is confirmation of the logical order in which to ask the questions that comes from Patney and adoption of that Patney list of questions. And we see that paragraphs 20 to 21, which are on page 107. So we see in paragraph 20, quotation of paragraph 73 in Patney that we looked at before, and then Lord Justice Kitchen went on, this is a helpful passage for it explains a structured approach which may usefully be adopted in deciding cases of this kind. Now what follows, highlighted, is the passage my learned friend cites, but again, I say viewed in its proper context, all that is an uncontentious statement of where ultimately the burden of proof lies on the question of what the basic hire rates are. And the last case I need to deal with, just because it's relied on by my learned friend, is McBride, which is at tab 8. And at paragraph 5, this is page 125 of the authorities bundle in the judgment of Lord Justice Flo. My learned friend says, effectively, here is another recent case saying the same thing. And of course it does. We see the highlighted passage at the top of the next page, but it's just the same statement. Again, there was no issue as to impecuniosity in this case, so it really, in my submission, doesn't take things any further. What is clearly the case is that outside the protocol, a claimant advancing a claim for credit hire charges where they are relying on impecuniosity in order to recover those charges have to, from the start, give full details of the basis on which they claim that they are impecunious, which will include full disclosure of their financial position, income, outgoings, debts, and so on. And we have in the authorities bundle the standard multi-track directions that are given in such cases. We have those at tab 19. And the particular paragraph is at page 379. It's paragraph 5 of these standard directions. You'll see that, as I mentioned, unusually, this is in the form of an immediate unless order, and it requires service of copies of 3 months of wage slips or equivalent documentation and 3 months of bank and credit card statements. And we also have, for completeness, an essentially identical, I think it is identical, paragraph behind tab 21 of the bundle at page 384, which is part of the sort of menu of case management directions that can be dropped into any order, that show that this is a direction for a credit hire case which can be given in any case where credit hire is being claimed. So, my lord, my ladies, that's what I propose to say about substantive law, and I come on then to the protocol itself. We have that behind tab 13 of the authorities bundle. In summary, this is intended to be a procedure for dealing with personal injury RTA claims within the fast-track limit where there are no liability issues and no major factual disputes. And we see its scope set out in paragraph 4.1 at page 224. But I think actually before I show the court that, I should first take the court to paragraph 3.1 above under the heading aims, because I do place reliance on the first of those aims. The aim of this protocol is to ensure that... I'm sorry, my lord. Page 224.
224, right.
And your lordship should see a heading aims towards the top of the page above paragraph 3.1.
Wrong direction.
The aim of this protocol is to ensure that, 1, the defendant pays damages and costs using the process set out in the protocol without the need for the claimant to start proceedings. And then if we go down to 4.1, which is a block of highlighted text, the court will see what the scope of the protocol is. Now, this is not, I should make clear in case there's any confusion, this is the version currently in force that has been in force since the 31st of May of last year. It is not the version which was in force at the time that we are concerned with, but the only difference relates to the alteration in the value limit for small claim RTA claims, where the pain, suffering and loss of amenity limit has increased from £1,000 to £5,000. But we see, first of all, in subparagraph 2 of 4.1, that there must be a personal injury claim. So the protocol doesn't apply at all in a pure bent metal claim. And then...
Is there a different protocol for bent metal claims? Is he picking up your jargon? I don't believe there is a specific one, and of course it wouldn't fall within the personal injury protocol, but there is, of course, there is a general overarching practice direction on pre-action conduct. But the issue about credit hire charges would arise in those cases, just as it does in personal injury.
Absolutely it does, Rick. Yes. Yes. So those would be ordinary Part 7 claims allocated to a track according to their value, but not subject, I believe, to any specific pre-action protocol.
That's one of the distinctions, that leads you to be calling this an island of injustice. It falls outside processes which, in all other respects, would engage with the issue on the basis that the authorities have described that you've shown so far.
Yes, exactly. So if you were to drive into somebody's parked car, then you're not going to be within this protocol. Or if there's an occupant but they're not hurt, you're not going to be within the protocol. But if somebody is hurt, then you are within the protocol. And what 3 and 4 establish is the value boundaries of the claim. And 3 refers to the protocol upper limit, and that takes us back to the previous page at paragraph 1.2, where we see a definition of the protocol upper limit. And we see that it's £25,000 where the accident occurred on or after the 31st of July 2013, which of course is inconceivable. Any claim now would not fall within that date range, and that matches the upper end of the fast track. And then otherwise, going back to 4.1, 4 sets a lower limit value of a claim for which the small claims track would be the appropriate track. But what is very important for these purposes is if we go on a page to 225, we see at paragraph 4.4 that vehicle-related damages are excluded for the purposes of valuing the claim. And there is no limit at all on the vehicle-related damages which can be claimed in a protocol claim, whether they are being claimed from the start, as was the case in this case, or whether they come in later, as we'll see they can.
And that's why one of the examples you gave, the higher charges were £90,000.
Yes, that was the Zurich case, Zurich and Emergy, where they were over £95,000. That will still be a protocol claim. And it might help the court just to see the definition of vehicle-related damages, so that's absolutely clear. That's back on page 223 at number 18 in brackets towards the top of the page. There's some highlighted text there, and it's D there, vehicle hire. And under this protocol, all communication between the parties takes place via an online portal. So these are sometimes referred to as portal claims. And the claim is commenced by the claimant sending through the portal what is called a claim notification form. And we see that on page 227. And it actually goes straight to the defendant's insurer. And this is part of what is called stage 1 of the process. If we look at paragraph 6.4 further down that page, we'll see that claims for vehicle-related damages are ordinarily dealt with outside the protocol, but they certainly can be dealt with within it, and were in this case. And if there is a claim for vehicle-related damages, then in the claim notification form, the claimant either has to say it's being dealt with by somebody else, or give details of the amount that they're claiming. But that's as much information as they have to give. And there are various points at which the claim can exit the protocol, depending on things that happen down the line. A general point to make was, which I'll make good when we look at the fixed cost provisions in due course, and is certainly in my submission material to how the issues that we're concerned with ought to be dealt with, we say, is that claimants are generally keen for claims to leave the protocol, because the fixed costs that are recoverable for a claim that leaves the protocol are considerably higher than those that are recoverable within the protocol. And while whether or not a claim stays in the protocol generally depends more on the actions of the defendant. Where there is a possibility that, for example, the claimant may take the claim out of the protocol inappropriately, then there can be cost sanctions. The claimant may ultimately be held to the cost that would have applied had the claim stayed within the protocol. And of course, that is there precisely because claimants may well be looking for reasons to take claims out of the protocol. So if we look at 6.15 on page 228, or probably actually 6.11 first, we see at 6.11 that the defendant has to respond to the claim notification form within 15 days. So that's a time limit imposed on the defendant. And then at 6.15, we see a list of circumstances in which the claim will not continue under the protocol. So it won't continue if, although there is an admission of liability, there is an allegation of contributory negligence, other than in relation to an admitted failure to wear a seatbelt. And of course, that reinforces the fact that this protocol is not intended to deal with contested issues of fact. It will also drop out if the defendant doesn't send the CNF response, and that also means on time. 3 does not admit liability, or under 4A and B considers either there isn't enough information in the claim notification form or that it's actually a small claim. And what we see over the page at 6.17 is what the consequences are of a claim leaving except where it leaves because it ought to be a small claim, in which case now what the claimant has to do is embark on the small claims protocol. But in the other cases, and in the circumstances that would have applied when the protocol that governed this case was in force, then it simply proceeds under the pre-action protocol for personal injury claims, the general PI protocol, and if proceedings are commenced, they will be ordinary Part 7 proceedings, and the only effect of ever having been in the protocol is that there will still be fixed costs, which will apply unless it's a multi-track case, in which case costs will be at large. If the claim has got to this point and has remained within the protocol, which requires the defendant to have admitted liability on time and not to have raised a contributory negligence issue other than admitted not wearing a seatbelt, we then come to stage 2. And stage 2 is where the parties seek to quantify and settle the claim. So at stage 2, if they haven't already, the claimant obtains a medical report. We see that referred to in paragraph 7.1 on page 229. And there are various provisions that I don't think I need to trouble the court with that relate to the obtaining of medical reports. I can pick this up, I think, at page 231, at paragraph 7.11, where it says, in most cases, witness statements, whether from the claimant or otherwise, will not be required. One or more statements may, however, be provided where reasonably required to value the claim. So there is an option for either party to put in evidence, but they don't have to. And of course, evidence was put in this case. The claimant then provides, once they've got their medical report, they've got the evidence of their losses, they provide what's called a stage 2 settlement pack to the defendant. And we see that referred to at the top of page 234.
We're just dealing with what information has to be put in at what stage. At stage 1, the CNF, the claim notification form, is filled in. On that, does the claimant put in a figure for vehicle hire or credit hire costs?
So under paragraph 6.4, if they are going to bring the credit hire claim within the protocol at the same time, if they can quantify it, then they have to attach invoices and receipts, but they may not be able to quantify it at that stage, in which case they don't have to. And it may be that they're dealing with those outside the protocol, in which case they don't have to say anything except these are being dealt with outside the protocol.
But if they do want to deal with them in the protocol, they have at least, do they, to say, we will be bringing credit hire charges, or...
Yes.
Right.
Yeah.
So the claim as a category of claim is flagged up.
It should be, yes.
But are you saying at that stage they should also plead, pejorative word, impecuniosity?
What I submit, my lord, is that the information which ought to be provided at stage 2.
Right.
So we don't demand that at stage 1. At stage 1, we know there is going to be a credit hire claim.
So all they have to do at stage 1 is flag up that that's a category
Yes.
of claim.
The structure of the protocol is that quantification takes place entirely at stage 2.
Right.
So the stage 2 settlement pack is the first time the claimant has to present the defendant with a fully quantified claim. And that is paragraph 7.32 at the top of page 234. And stage 2 is a process of potentially exchanging offers and seeing if the claim can be settled.
It's the negotiation stage.
Exactly, my lady. There is still, if vehicle-related damages have not been brought in yet, it's still not obligatory to bring them in at this stage. It's only at the stages we'll see of court proceedings having to be issued that they have to be brought in. So if the claimant is dealing with those separately, at this stage there won't be any reference to them in the stage 2 settlement pack. It will just deal with the other losses. And paragraph 7.35 at the bottom of that page provides for the consideration period, and the defendant is under time pressure to make an offer, and then there is a period in which the parties can continue to negotiate. And the claim will leave the protocol if at this stage the defendant thinks it's actually a small claim. And we see that at paragraph 7.39 over the page at 235. And we also see that it will drop out of the protocol if the defendant doesn't respond in time to the stage 2 settlement pack. And then we see it in 7.41. If the defendant is making a counteroffer, they have to set out their case on a head of loss by head of loss basis. And there is an obligation,
Sorry,
you can see.
I'm feeling my way in this. So at a number of stages, the defendant, either by saying it's a small claim or by just not engaging, drops out of the case drops out of the protocol. The thing that keeps defendants hanging on in there is that it is cost effective.
Absolutely, my lord. I mean,
so what's in it for them is the summary, cheaper litigation with early resolution.
yes, yes, absolutely, my lord. And the protocol is predicated on it being to the defendant's advantage in terms of costs, of course, to keep claims within the protocol. So if a claim drops out, it will either be because the defendant has done something wrong, like failed to comply with the time limit, or it's just an unsuitable case because there is a liability issue or a contributory negligence issue.
Yes. Or the defendant, instead of doing something wrong, might simply sit on their hands, just not take part, and let it then progress into Part 7.
Yes.
Litigation in the ordinary way.
I mean, that would be a breach of their obligations under the protocol, so their exposure
They're
then...
expected to engage.
Yes, it would be regarded effectively as a sanction that the claimant is then entitled to take it out of the protocol and commence Part 7 proceedings.
So it's really, if one reads 7.41, that is the stage at which the defendant really has to spell out his or her case.
Yes.
Because it's in 3 parts, isn't it? They've got to make a proposal as to any counteroffer, then explain why a particular head of damage has been reduced, and the reason being is to allow both parties to focus on really what is agreed, what isn't agreed, and what the difference is. That's it, isn't it?
Absolutely, my lady, yes. Yes. So the defendant is very clearly subject to a cards on the table obligation.
Yes.
Now, if settlement can't be achieved within the negotiation period, that's when we come to court proceedings and the need to bring in vehicle-related damages. And that's dealt with on page 237, beginning at paragraph 7.51. And it's the highlighted text from 7.51 to 7.54. And in essence, this only applies if, at the end of the negotiation period, what are called the original damages, which are the claims that were being dealt with through the protocol, have not settled. So if all of those claims have been settled and there was a credit hire claim being pursued outside the protocol, it stays outside the protocol. But if any aspect of the protocol claim has not settled, then it stays within the protocol and the vehicle-related damages have to come in. And there's essentially a second stage then of exchanging information and exchanging offers. And again, we see in 7.54, there's an obligation on the defendant to put forward a reasoned position on any counteroffer. Now, the upshot of this further stage of negotiation may be that the credit hire charges remain in dispute, but everything else has now been settled. And if that is the case, so in a case where credit hire was outside the protocol, it's brought in at the end of stage 2, and at that point everything else is settled, the credit hire falls out of the protocol again, and it stays outside in part 7. But having been brought in, if anything in the original claim remains in dispute, then everything stays within the protocol when it comes to issuing proceedings. And we see that dealt with the 4 possible scenarios between 7.55 and 7.61. And then 7.64 provides for what's called the court proceedings pack. So this is the prelude to issuing proceedings. That the claimant puts together a pack which sets out both parties' positions. And the structure of the protocol is that the parties' cases at that point are effectively set in stone. So we see at 7.66 that comments in the court proceedings pack, Part A form, must not raise anything that has not been raised in the Stage 2 settlement pack form. So the idea is that both parties during Stage 2 have to set out their full stalls, and they are then held to those positions, in effect, when we move on to issuing proceedings. So no new arguments and no new evidence.
That's your cards on the table.
Yes, my lord. And so what is, I hope, obvious, and what we say in the skeleton argument, is that when it comes to issuing proceedings, whether a credit hire claim is inside or outside the protocol is going to depend on a number of factors that have nothing to do with its value and nothing to do with the issues in dispute in that claim, and not necessarily matters within the defendant's control either. So they will depend on, as I've already said, whether there's any personal injury in the first place, whether time limits were adhered to, whether liability was admitted, whether there was contributory negligence, and whether the parties were able to settle the protocol claim before the end of Stage 2. Before leaving the protocol and moving on to the practice direction that deals with proceedings at Stage 3, it's also relevant to show the court paragraph 7.76 at page 239. There is here in this paragraph a general power for the claimant to give notice to the defendant that the claim is unsuitable for the protocol. And an example is given of there being complex issues of fact or law. But this is essentially a unilateral act. It's not adjudicated upon at that stage. If the claimant gives notice, the claim will leave the protocol. There is, however, as we see, the retrospective power effectively to decide that the claimant was not justified in doing so by holding them to the fixed costs that they would have had under the protocol. There is no equivalent power for a defendant. If a defendant wants to take a claim out of the protocol because they think it's just not suitable, then they are going to have to engineer a way of doing that by, for example, ignoring a time limit or doing something else which will automatically cause the claim to drop out. But there's no equivalent of this provision. And then, as is said in paragraph 8.1 at the end, the stage 3 procedure is set out in practice direction 8b. And we have that behind tab 15. If we can go there, this is much shorter, and there's not that much of it, I think, that I need to show the court. This is, in essence, a modified form of the general Part 8 procedure. We see in paragraph 2.1, well, first of all, perhaps it's relevant just to look at 1.2 above that on page 298. So these claims are started in the county court. They're generally dealt with by district judges. And then at 2.1, we see that it's made under Part 8 as modified. And then we see in 2.2 at the top of the next page what those modifications are. And they include, for example, disapplying all of the rules in Part 8 that relate to evidence. At page 300, at paragraph 6.1, we have a list of the documents that have to be filed with the claim form. And we see at 6.3 that subject to paragraph 6.5, which only applies where the claimant is a child, the claimant can only file documents where they've already been sent to the defendant under the relevant protocol. So this is an aspect of the positions being set in stone at the end of stage 2. And then we have provisions relating to evidence and what are the crucial 2 paragraphs really for this appeal at page 301, 7.1 and 7.2. So 7.1, the parties, and that of course is both of them, may not rely on evidence unless it's been served in accordance with 6.4, and that of course is evidence previously produced during stage 2. It has been filed in accordance with 8.2 or 11.3. That's concerned with matters that we don't need to trouble ourselves with here. Or under 3, where the court considers that it cannot properly determine the claim without it, the court orders otherwise and gives directions. So there is a general power for the court to order that further evidence be required, and in those circumstances the claim can stay within the protocol. And then at 7.2, where the court considers that 1, further evidence must be provided by any party, and 2, the claim is not suitable to continue under the stage 3 procedure, the court will order that the claim will continue under Part 7, allocate the claim to a track, and give directions. Now, it is relevant to note some of the editorial comment that appears in the White Book on this power. The first point that I draw attention to is at the very bottom of that page, where it's stated the power of the court to order that the claim is not suitable to continue under the stage 3 process is a power the court may exercise on its own initiative. And as the provision is worded, I respectfully submit that that must be right. There is then over the page a reference to a judgment of this court of Lord Justice Jackson that we will look at in due course, Phillips and Willis, on which we say an unfortunate and unjustified gloss has been given in the White Book, which is actually causing problems in practice. And that is the final sentence of the commentary there, where it says, the case illustrates that transfer out of the protocol stage 3 procedure to Part 7 will be rare and for exceptional cases only. Now, that, as I will make good, is a misdescription of the effect of Phillips. And whatever else happens on this appeal, in my submission, that is a misdescription which needs to be corrected. If we then move on to paragraph 9.1 further down the page, we see that if the claimant attempts to introduce new evidence, the defendant can object to that in its acknowledgement of service, and that will result in the claim being dismissed, and the claimant starts proceedings under Part 7. The determination of the claim, in whatever form it is undoubtedly brief. It can be on the papers, that's provided for in 11.11. If it's at a hearing, it seems that county court practices vary, but it is not uncommon for these hearings to be telephone hearings listed for 15 minutes, and that was what happened in this case. Clearly no live evidence is called, and the extent of the argument is very brief indeed. I will now, if I may, just briefly show the court what the fixed costs provisions are that govern claims that stay within the protocol and claims that come out of it, to illustrate how different they are. I can do this very quickly. The relevant parts of CPR 45 are behind tab 18 in the authorities bundle. And I'm just going to focus on profit costs for these purposes because that's what's really relevant here. So solicitors' fees. And we see at 4518 a table of fixed recoverable costs, and the figures depend to some extent on whether the claim is worth more or less than £10,000. Type C fixed costs are irrelevant to our purposes. That is providing advice where you've got a claim on behalf of a child. If we ignore that, then in the higher value bracket claim, the maximum profit cost that can be recoverable is £1,300 plus VAT. There will also be a 12.5% uplift if the solicitors are in London, but the basic recoverable charges are what's set out there. The costs if a claim leaves the protocol are rather more complicated, and I will simplify, I hope not unfairly for these purposes, just to deal with the headline figures. They are dealt with in section 3A of part 45, which begins at page 366. And we see, first of all, in Rule 45.29a, the scope of this section, and we see that it governs claims that leave not only the RTA protocol, but there are very similar protocols for employers' liability and public liability claims. And then we see in 45.29b that these don't apply if the case is allocated to the multitrack. So if a case comes out of the protocol and its total value takes it into the multitrack territory, then costs are at large in the usual way. So these are essentially fast-track cases that come out of the protocol and remain on the fast track. And we then have, at 4529C, at pages 368 to 369, a slightly alarming-looking collection of tables that govern payments in various circumstances, but I can simplify this by just focusing attention on C, if the claim is disposed of at trial, at 369, where we see that the fixed cost of the total of £2,655, 20% of the damages agreed or awarded, and C, the relevant trial advocacy fee. So if we assume a claim of maximum value within the fast track, which would be £25,000, then that puts the advocate's fee under table D below at the top end, and the total amount of costs that are going to be recovered in those circumstances is going to be £9,360 plus VAT. So that is about a 7-fold increase on the cost for the same claim dealt with through the portal. Now,
just pausing. I'm sorry it's so cold in here. I can see at least one person. We're all feeling it. I think there's nothing we can do about that.
well, look, there may be some device in front of your lordship that offers some control.
No, I have a range of controls. None of them. I've got something called plant override. There is, in fact, the temperature is, the button doesn't seem to move, but there is a temperature button. But I think it was right over at the maximum.
I did ask the associate if perhaps the temperature be increased a little, and she did go up there and press something. Whether it made a difference, I couldn't say.
I could press plant override. Heaven knows what will happen. If you know what, then you're certainly, any knowledge will be greater than mine.
Yes.
Well, we've done something. At least it makes us feel better that we've done something. But whether it makes any difference.
Thank you, my lord. Now, of course, I take as the starting point, as I have to, that there's clearly nothing in the protocol which requires a claimant to produce anything in support of a claim of impecuniosity. There isn't even an obligation to provide a witness statement, though, of course, a claimant can elect to do so, and that happened in this case. But if a witness statement is provided, there's no obligation to provide any supporting documents. And what we really focus on in this appeal is the contrast between that and three categories of claim, which between them cover every other field of civil litigation in which this issue might arise. So it obviously contrasts with a claim which was never in the portal because the value of the non-vehicle element put it in the multi-track, or because there was never any personal injury element. And that would be the case even if, otherwise in value terms, it was a fast-track claim. It obviously contrasts with a claim which begins in the portal but leaves it. And it also contrasts, which is why we say that this is a unique lacuna, really, in the field of litigation, is that under the new rules now governing small claims since May of last year, it also contrasts with the treatment of those claims. And to make that good, and also to answer, when it comes to it, submissions that are made about the costs that would be unfairly foisted onto claimants in the protocol if they had to deal with these sorts of claims in the same way, I'll take you, if I may, on a whistle-stop tour of the key provisions of the small claims protocol, which we have behind tab 17 of the authorities bundle. It is a dauntingly long document, which is apparently intended to be used by litigants in person, but there we are. It covers lower value accidents which occurred from the 31st of May of last year. And credit hire under this protocol is a form of what's called a non-protocol vehicle. So I may actually have given the court the wrong reference. It's tab 14. I think I said 17, and that was my mistake. It's tab 14.
Thank you.
The document behind which is even longer. So it's paragraph 1.2 is a very long list of definitions beginning at page 241. And what we have at the bottom of 244 is a heading, Vehicle Costs Definitions.
Thank you.
And they're divided into protocol vehicle costs and non-protocol vehicle costs. And within the category of vehicle costs, we see that at D, the cost of hiring a vehicle is a vehicle cost. And then over the page, the essence of the difference between them are protocol vehicle costs have been paid or dealt with by the claimant themselves, and non-protocol vehicle costs are payable to a third-party organisation or business, and that catches a credit hire claim.
And these are supposed to be understood and worked by litigants in person.
My lady, they are. Perhaps no further comment is required.
I don't feel so bad about the family procedural. Right.
If we then come on to the scope of this protocol, that's at page 248. And we see at paragraph 4.2 a heading, when to use this protocol. And we see at 1 that the date cut off in terms of the accident, and also that at 3, that's effectively the upper value limit that reflects the small claims track generally. And again, we see that non-protocol vehicle costs are excluded for the purposes of valuing the claim.
Right.
Now, what is different under this protocol is that credit hire claims cannot be dealt with within the protocol. That certainly appears to be the implication of paragraph 5.14, which is on page 252. It doesn't actually say that in terms. 5.14 is more of a statement of fact than a direction, but it seems to be implicit that at least at the outset, those will be dealt with presumably directly between the credit hire company or their lawyers and the insurer of the third-party driver. But again, as with the higher value protocol, if proceedings are issued, then these claims have to be brought in. And we see that at page 280 of the bundle. There is a heading, claims for non-protocol vehicle costs. And it's 11.11 provides for the position during the protocol, and then 2, the bringing in of those costs if the claim is going to be issued. Differently from the higher value, the fast track protocol, we see over the page at 11.6 that if adding the credit hire claim to the existing claim now takes the whole claim above the £10,000 limit, the claimant can take it out of the protocol. So that is a difference between the two. So it will stay within it if once you add the credit hire charges, you are still claiming less than £10,000. And if you're going to make those claims, at that point you have to give, as we see in 11.7, you have to give specific details of the claim and the facts in support of it. And it's a document, a pro forma document, which appears at Annex C to the protocol, and it begins at page 292, going on to 294 of this bundle. So this is what the claimant has to fill in at the point when they're bringing these sorts of charges into the claim, and there are various boxes to fill in for different categories of cost. And if we go on to 293, we see at D, one category is temporary vehicle. Various things the claimant is expected to say. This is almost in the nature of a pro forma witness statement because the claimant has to sign a statement of truth at the end. And so we see, for example, the second box from the bottom on 293, the rate of hire is reasonable for the following reasons. You must state all facts relied upon you to explain why the rate of hire was reasonable. Then we have the period, and then at the bottom, a bullet point, my claim for hire is a claim for credit hire. I was unable to afford to pay for the hire myself. This is known as impecuniosity. For the following reasons, you must state all facts relied upon, that should say, by you to explain why you were not able to afford to pay for the hire of the replacement vehicle. And then there's a box that the claimant can complete. I was able to meet the cost of the hire because. And then an important warning to the claimant underneath that, I understand that I will be directed by the court to disclose financial and other documents supporting my response in impecuniosity after proceedings have been issued. And then the claimant has to sign that statement of truth. There, my lord, my ladies, we can leave the protocol and finally, on this journey through the practice directions, come to practice direction 27B, which deals with issued small claims, and that is tab 17 of the authority bundle, where I erroneously directed the court before. And all I think I need to show the court here is that there are model directions in various appendices to this part of the civil procedure rule, which will be given in cases where there are claims for credit hire. And they appear generally in Appendix B, which begins at page 346 of the authorities bundle. There are different directions depending on exactly what is in dispute, but the first two, the first two sets of model directions contain identical provisions to deal with non-protocol vehicle costs. Paragraph 5 requires the claimant to serve a witness statement dealing inter alia with the issue of impecuniosity. And then paragraph 6 deals with disclosure of documentary evidence, again, in the form of an unless order, which requires them actually to provide slightly more than would be required on the multi-track. So most of this mirrors what we saw earlier as the standard multi-track direction. It's 3 months of wage slips or other evidence of earnings and 3 months of bank and credit card statements. We've also got here little Roman 3 details of all investments held at the time of the accident. That actually goes beyond what would be required in a multi-track or fast-track claim. But what matters for these purposes, for my purposes, is that this is required of claimants pursuing small claims. And it remains the case in these sorts of claims that there is generally no or minimal recovery of costs. So you get your issue fee back, you get your medical report fee back, but you don't get anything for profit costs. This is expected to be done by claimants at their own expense. So, my lord, my ladies, having gone through all of that, that really sets the scene for what is at the heart of this appeal, which is insurers, in my submission, legitimate concern that while a credit hire claim remains in the protocol at stage 3, claims may go through on the nod based on nothing more than an unsupported assertion of impecuniosity, as happened in this case. And fundamentally, what we submit is that there cannot be any justification for subjecting such claims to a different forensic approach from all other claims of equal higher and lower value. So there has to be a way of squaring that circle. There has to be a way of achieving justice while at the same time respecting the aims of the protocol. Now, having identified that as the issue, looking at the respondent's skeleton argument in this case, it may well be that there isn't a great deal of opposition to that basic proposition, that there needs to be a mechanism for dealing properly with contested allegations of impecuniosity. What Milan and friends appear to say is that the answer is to drop a contested claim out of the protocol and into Part 7 using paragraph 7.2 of PD 8b or the more general power in CPR 8.13. And yes, that is an answer, but we submit it's not the right answer. And that is where really I perceive that we part company on the principles and on the issues on which we seek broader guidance. Because yes, were every disputed claim or every claim in which impecuniosity might arise at all to be dropped out of the protocol, that would, of course, avoid our rubber stamping concern, but it would carry undesirable consequences across the whole cohort of claims, which I'll make good, and we submit it should not be the primary approach. What is required is a more nuanced approach than simply taking every claim of that kind out of the protocol. But before I get into that, this may be a convenient moment just to deal with the Phillips and Willis issue and what it actually says about the circumstances in which claims may or may not leave the protocol under paragraph 7.2. It's the scope of the decision is obviously relevant to the issues that we have to grapple with, but also, as I've shown the court, it does appear that the extent of what was decided does appear to be misdescribed in the commentary in the White Book. It's tab 7 in the authorities bundle. Fundamentally, what I submit this case is a decision on its own facts. The essence of those facts is that this was a case that reached stage 3 with only the higher charges in dispute, at a point when the parties were only £462 apart. And we see that for reference in paragraph 28 on page 119. There was no issue as to...
Maybe I misheard you. I thought some short time ago you said that if you get to the cusp of stage 3 and the only issue is the higher charges, then the case falls out of the protocol. Did I misunderstand that? And it only goes forward if there's something else to hang on to that's within the protocol. Did I misunderstand that?
My Lord, what must have happened in this case, and I'm sure someone will tell me very quickly if that is spelled out, is that the credit hire charges must have been an issue in the protocol. Right. Because if they are, then the case will always stay in the protocol. Okay. Because that must be the case, because the particular reason why the district judge in this case unilaterally dropped the case out of the protocol was because everything else is settled. And we'll see that. So the extent of the dispute over the credit hire charges, it was really a quantum one, and it had nothing to do with impecuniosity. And we see that in paragraph 25, just for reference, in the penultimate sentence of paragraph 25. And we also see in the same paragraph that the defendant was quite happy to argue the points based on the evidence that the claimant had produced. So the parties had turned up for the stage 2 hearing, or got on the phone, whichever it was, for the stage 2 hearing, and were quite prepared to argue there and then over what was only a few £100s of difference between them. And the district judge took it upon himself, just because there were only higher charges left to argue about, to use the power in paragraph 7.2 to transfer the case to part 7 and to give directions. And we see that in paragraph 18. We see that actually this was a hearing in person, and the district judge made his own decision to take the case out of the protocol. Now, a point which was of great significance then to Lord Justice Jackson's decision, and would not arise now, is that leaving the protocol then, under the version then in force, would have dropped the claimant at the small claims track, where there would have been no cost recovery. Whereas the rules had changed. In fact, by the time Lord Justice Jackson gave his judgment, and he noted that, the rules have changed to what they are now, so that a claim which falls out still is subject to recoverable fixed costs. And we see that the ensuing cost consequences were of particular concern to Lord Justice Jackson at paragraphs 29 to 30, at pages 119 to 120, And he sets out in full the directions that were given and expresses his concern at what the cost of compliance with them would be in circumstances where no costs would be recoverable. Now, in my submission, the only observation of principle that was made by the Lord Justice in this case appears in paragraph 33, where he noted that a case does not leave the protocol just because the personal injury element is settled. And he says, on the contrary, the RTA process is carefully designed to whittle down the disputes between the parties as the case passes through the various stages. And then the final sentence is really the expression of principle. The mere fact that the personal injury claim has been resolved is not specified as being a reason to exit from the RTA process. And that being the case, he then went on in paragraph 34, that essentially there was no power to use paragraph 7.2 to do what the district judge did. He then goes on in paragraph 35 expressly not to give guidance on when that power might be used. He says there has been some debate as to the circumstances in which that paragraph might apply. We do not need to decide that question today. And he, however, notes, and all he does is note, that there are claims proceeding under the protocol which involve very high car hire charges. And such cases might involve complex issues of law or fact which are not suitable for resolution at a stage 3 hearing. I need not speculate what orders the court might make in those cases. Suffice it to say that the case before us is not such a case. So his lordship was very careful not to put any gloss or limit on the circumstances in which the power might be used. It just wasn't appropriate to use in the case before him. And I say with respect to the editors of the White Book, it is quite difficult to understand from the judgment where the statement has come from in the editorial comment that only rare and exceptional cases.
So I'm just looking at the White Book. It says, as you took us to, the case illustrates that transfer out of the protocol stage 3 procedure to part 7 will be rare and for exceptional cases only.
Yes. Now I'm told, my lord, that this is causing real problems in practice because judges are taking the commentary as being reflective of the judgment and are deciding that since there is nothing rare and exceptional about, for example, a £20,000 credit hire claim being made within the protocol, the fact that you have a £20,000 credit hire claim that you want to challenge is not a reason to take it out of the protocol. And in fact, we'll see that it was a comment also relied upon by the learned circuit judge in this case when she gave her judgment. So I turn then, my lord, my ladies, to what we submit in the general way of things should be the approach to credit hire claims where impecuniosity is inevitably going to be relied upon. And what we say is that claimants should, in the first instance, at stage 2, be required to evidence properly a claim of impecuniosity with production of the documents which would be required in any other forum. And I do stress any other forum. And then the defendant should be able to make an informed choice between 3 alternatives, taking into account the value of the claim and the cogency of what has been provided. And those 3 alternatives are, firstly, the defendant might simply accept the evidence and agree that the claimant is impecunious. So that's fine, issue resolved, the claim can stay within the protocol. Option 2 is that the defendant might take the view that the evidence is simply insufficient to meet the target and therefore might be prepared to take their chances at a stage 3 hearing within the protocol of persuading the judge that that was the case. Again, the claim would remain within the protocol. And the third option would be to take the view that the evidence requires proper challenge, and in those circumstances, to take the case out of the protocol at stage 3 so that there can be cross-examination and whatever else might be necessary. And I make 5 points.
Well, before you do, Mr.
Yes.
Carpenter, can I just ask this? As to B, that the evidence is insufficient to meet the target, and you're in stage 2, the negotiation, and you've got, is it that particular provision, is it 7.4, as my lord put it, the cards on the table provision? Do you say at that stage it's incumbent on the defendants to identify the fact that, in the defendant's opinion, the evidence is insufficient to back out to their...
I couldn't contest that. It is a cards on the table approach, and there must be a similar obligation on both parties. So one assumes that in a case where, notwithstanding whatever guidance this court might give, let us just suppose that the outcome of this appeal, if it's not too presumptuous, is a direction as to what claimants must do in future, and they don't do that, I would quite accept that a defendant would have to say, you haven't done it. Now, if the claimant then does it, well, the defendant can choose between options 1 and 3. If the defendant has taken the point and the claimant does nothing more, then the claimant can have no complaint if the defendant says, fine, I'll see you in court at stage 3, and I'll ask the judge to find against you. My lord, my ladies, in submitting that that is the correct approach, rather than the blunt instrument of just taking every case out into Part 7, I say that 5 points are relevant. Firstly, if the defendant has to make a decision before the claimant has put their cards on the table, and before the defendant has any idea how strong the claimant's claim to impecuniosity actually is, the practical effect is going to be that every credit hire claim where impecuniosity might be an issue will have to be taken out, which is very obviously contrary to the letter and the spirit of the protocol. And I showed the court earlier paragraph 3.1 of the protocol, which expressly states that one of the aims is to avoid proceedings being issued. And you also saw a moment ago what Lord Justice Jackson said about the desirability of keeping claims within protocol. So it's obviously contrary to that. Secondly, I submit that claims which can be dealt with inside the protocol should be. There is no reason why a claim in which a claimant can easily demonstrate impecuniosity to the required standard should leave the protocol. There's just no need for it. Thirdly, I submit that requiring the claimant to make out their case first is consistent with the approach in all other forms of litigation, which we've seen amply demonstrated in the authorities. It reflects the general principle that defendants are entitled to know from the outset the case that they have to meet. And it could also be said, with specific reference to the protocol in the paragraph that my lady directed my attention to, it's simply reflective of the obligation on defendants, the express obligations on defendants under the protocol to take a cards on the table approach. The fourth point is that as we've seen, taking a case out of the protocol significantly increases the fixed costs payable. And if every credit hire case falls into a higher cost environment, not only does that undermine the aims of the protocol in themselves, but that is not going to be for the benefit of motorists if the result of that is, for example, that premiums go up. And this is a system which was the product of a good deal of consideration and negotiation between interested parties, and it would drive a large wedge into the operation of that system. Now, in response, what is said by the respondent is, well, in demanding this of us within the protocol, you are going to make us do more work, you are going to put up our costs, and there is something of an interorem submission that it would just make these sorts of claims.
This is what claimants would say.
This is what claimants will say. This is what is said in the Lerner Friend skeleton argument, that there's an interorem submission that this will make claims uneconomical. Now, I can say, first of all, that claim like that needs to be viewed with a certain degree of circumspection when, as I've already said, it's generally in claimant's interest to take claims out of the protocol. If all of these claims fall out of the protocol, those who act for claimants are going to be perfectly happy about that because of the increased cost recovery. In terms of the work required, what I say is it is no more than is required for a small claim where there is no costs recovery. And fundamentally, nothing in the protocol says you don't have to prove your case. It may be a streamlined procedure, there may be fixed costs, but you still have to prove your case. And in this case, the claimant served a witness statement, even though he was under no obligation to do so, because that was considered necessary to prove his case. And there will be many cases which require some work to be done, which is not strictly mandatory under the protocol, because otherwise the claimant will not have proved his case. And actually, it might be said that drafting a witness statement is more labour intensive than asking clients to produce standard documents. And if this is what is required of claimants, then what solicitors will no doubt very quickly develop, and they should develop, is pro forma advice to their clients to gather together the necessary documents. And that is a task for the client. It's not a task for the solicitor. That's what clients should be asked to do, and it's what they should do. And the small claims protocol shows that it is reasonable to expect clients pursuing their own claims to do that. It's not difficult to get 3 months of wage slips. It's not difficult to get 3 months of bank statements. And one can also add that, yes, the fixed costs are low. Certainly they are. But they are concerned with what is recoverable inter partes. They are not concerned with what solicitors can charge their own clients. And invariably, in these cases, solicitors do charge their clients more than the fixed costs. These claims will often be conducted under conditional fee agreements with success fees, and very often the arrangement will be, because of course the success fees are no longer recoverable, that there will be an agreed cap on deductions from the client's damages, often a percentage, perhaps 15, 20, 25%. So clients are going into these claims knowing that their solicitors are going to do more work than the fixed costs will pay for, and they are content to pay some of their damages for that work. And then finally, my lord, my ladies, the fifth point, the requirement to produce this information during stage 2, or when these charges are brought in at the end of stage 2, will increase the chances of settlement without proceedings having to be issued at all, which is, as we saw, one of the aims of the protocol.
Yeah.
So, even though this is, I quite accept, of course, not expressly required by the protocol, what I submit in summary is that during stage 2, a claimant who is seeking to persuade the court that they are impecunious should produce the evidence and the documents which would be required in any other proceedings. And if they do not, if what they put forward is a bare assertion with no details, or they do not produce those documents, what the court should do at stage 3 is simply conclude that the claim of impecuniosity is not made out. And that reflects the approach that we see in paragraph 17 of Hussein. And yes, I accept, of course, that Hussein was not a protocol claim, it was a Part 7 claim. But the statements as to the forensic standard required are, in my submission, of universal application. It is not enough just to say, I couldn't afford not to work, or just, I am impecunious, which I'm told is sometimes all a statement will say. And if a defendant, if a claimant hits that target, prima facie hits that target, at stage 2, and the defendant wants to challenge that evidence, then the court ought, in the general run of things, to accede to a request to transfer the case out to Part 7. And that can actually be quite conveniently done in the acknowledgement of service. And we've got actually an example. It might interest the court to see at tab 16 of the authorities bundle. There is a special acknowledgement of service for claims of this kind. And the fifth box that the defendant can tick under Section A is I object to the use of the procedure in Practice Direction 8B. My reasons for objecting are. Now, under the protocol, one of the existing reasons for the defendant invoking that is if the claimant produces new evidence that they haven't produced before. But there's no reason in principle why the defendant shouldn't be able to put there, I wish to challenge the claimant's evidence of impecuniosity, and therefore this is no longer a suitable claim to remain in the protocol, and that the court should, in my submission, ordinarily act on that by taking the claim out. And the claimant is very unlikely to have any objection because they will then get the increased costs. My lord, my ladies, that's all I want to say about the principles. What I have not yet touched on and need to turn to now is what actually happened in this case. Yes. And I do need to address the submission which is made against me, that the points that we are seeking to raise are just not open to us. And I'm afraid that does mean that I have to go through more of what happened below than I otherwise would, but I'll do it as efficiently as I can.
Before you do that, in terms of the flaw, I think you're saying that there is in the protocol because it doesn't permit the parties to engage with this issue of credit hire agreements and impecuniosity, and that there should now be some statement from this court that brings these issues in. The protocol is a protocol, but it has the same standing in law as the rest of the civil procedure rules. So if it's in black and white in the protocol, then what latitude does this court have to change that? We can be grumpy, we can say this doesn't look right, and this should be changed, but we ourselves can't change the protocol, can we?
No, my lord, and I certainly don't ask this court to rewrite the protocol, but I submit that's not what I'm asking the court to do, because nothing in the protocol prohibits what I say should be the requirement.
So we should, in our judgments, if we're with you, I'm just feeling my way as to what it is, what the mechanism is that you're asking us to use, we should issue a commentary, as it were, to say that if this issue arises, then the protocol can be used, provided that this step or that step is undertaken. So we're adding to the protocol by what we may say in our judgments. Is that
it may not even be adding. I would put it in this way. I would ask, what I ask the court to do is, I think, two things. Firstly, to set the evidential standard for claims of impecuniosity at stage 3 under the protocol. That has nothing to do with amending or glossing or rewriting the protocol in any other way. That is simply setting the evidential target that claimants have to hit and setting it so that it accords with what was said in Hussein and what would be required in any other claim, in fact, of any kind.
Doesn't that mean setting a standard at stage 2?
Yeah.
Yes.
And yes, so what follows from that is, at what point in the process should this happen? Well, it follows from the existing provisions of the protocol that it would have to happen at stage 2 because everything has to be set in stone by the end of stage 3. So again...
At the end of stage 2.
Sorry, by the end of stage 2, yes, by the end of stage 2. So it would necessarily have to happen at stage 2 because that's when both parties set out their stalls. And again, nothing in the protocol contradicts that or prevents it. It is just a question of, in evidential terms, the target that a claimant bringing a credit hire claim has to hit.
Right. So the protocol currently doesn't require a claimant expressly to do any of this at stage 2, but you say they can, and we in our judgment ought to say that they should.
Yes, and that if they do not,
yeah,
a judge is entitled to conclude at a stage 3 hearing that they have not proved the issue of impecuniosity.
Right.
That's why we say it's an evidential
But
point.
what about the idea that this issue is something that should come out in the wash at stage 2? Because there's so much toing and froing at stage 2 that by the end of stage 2, if impecuniosity is an issue, that should have been identified by the parties as part of the stage 2 process.
Well, my lady, there are two aspects to it. There's identification of it as an issue. Now, that clearly happened in this case. There's no doubt that the issue of impecuniosity was put in play. And then there is the separate question of, once it's in play, what is required on the part of the claimant to make good their case. And at the moment, the first part is adequately catered for, but the second is not. And then the other, and this would, I suppose, be something of a gloss on the protocol, but really just an indication of the proper use of the powers in paragraph 7.2 of ED.
Sorry, Ms. Hunter, before you go
Yes.
on, so your submission can't be then that right at the beginning of stage 2, the claimant should put all this material in. The claimant should only have to put it in if it's actually an issue between the parties as a result of the toing and froing at stage 2.
Well, my lady, there's, in essence, how you get there, we don't really mind, as long as by the end of stage 2, it's understood that claimants have to have produced everything they intend to rely on and what the evidential standard they have to meet is. The way the protocol operates, the claimant is supposed to produce everything in one go when they produce their stage 2 settlement pack. So it would be more in accordance with the spirit of the protocol and its letter in my submission for claimants to produce everything they rely on in one go in their stage 2 settlement pack, so that the defendant can then do what they are obliged to do in terms of responding to it. The protocol doesn't envisage, I would submit, the claimant's position being augmented, as it were, throughout the negotiation period. I don't say it's impossible. And as I say, we don't really mind as long as the position is clear by the end of stage 2, but it would seem to be more in accordance with the protocol for it all to be done in one go.
Well, you say that, but if we go back to, again, the point about what issue the defendants have to take, if there is no specific requirement in the protocol for the claimant to produce documentary evidence of impecuniosity, and you have accepted that within stage 2 it is incumbent on the defence to raise any issues as to the lack of evidence in respect of specific points taken, and that rather negates or certainly undermines the point that it's for the claimant at the very outset to produce the documentation.
Well, my lady, there may be an element of cart and horse here. The claimant, we would say, the claimant has to make clear their position at the outset, which, as it would be in ordinary litigation, which requires them to say exactly why they were impecunious or claimed to be impecunious. Now, if they've done that, there is obviously an obligation on the defendant to respond to that, and if they're going to contest it, to do so. I'm very conscious that the particular question your ladyship puts to me does trespass somewhat on the issues raised by the other appeal, and I'm also very conscious that I don't want to do anything to queer my learned friend's pitch in that regard. For the purposes of our particular appeal, it doesn't matter because the issue was clearly raised, and the question is, having raised it, did the claimant do enough then to prove that he was impecunious? But there must clearly at some point be an obligation on the defendant to say what their position is. But what I say, it ought to follow the claimant setting out their store. But if the order of events is claimant says in general terms, I'm impecunious, and defendant says, we don't necessarily accept that, please prove it, and the claimant then comes back with the material, and the defendant can then consider it, and this is all taking place at stage 2, then I'm sure we would have no objection to that as an order of events.
I'm not asking you to deal with it now, but you are going to have to deal, with your case, factual case on impecuniosity as you set it out on the 4th of June. I'm flagging it up. I'm not asking you to deal with it now.
Yes. Well, I was actually going to go now since...
Sorry, I'm going to interrupt again. Am I right that you, in saying the claimant should put the claimant's case on impecuniosity in the stage 2 settlement pack documents, because if they're making a credit hire claim, because that is almost inevitably a higher claim than will normally be allowed, it will only be allowed because they're claiming impecuniosity. So if they've got a credit hire claim, they're going to have to raise impecuniosity, so they ought to do it early doors, as it were, at the beginning in the settlement.
Exactly. There isn't,
because there aren't any really other. If that's what they're claiming,
yes,
there aren't any other roads to go down in order to justify it.
Yes, I mean it's slightly artificial, really, to imagine the claimant not anticipating it, the defendant having to raise it, and then the claimant addressing it, because, as my lord said,
it's always
going to
go down that route.
And the position may be slightly different in a Hussein case, which is what this particular case is, where it goes to the question of what is the measure of loss. If the claimant is a taxi driver who is, let us say, claiming 10 times his lost income as credit hire, that claimant can have no doubt at all that as a matter of law, they can only make good that claim if they can prove impecuniosity or one of the other potential justifications for having incurred those charges.
Can't one turn it round the other way and say that if everybody knows that the only kind of claimant who can make a credit hire claim is an impecunious claimant, then it's up to the defendant to challenge that if the defendant wants to make an issue out of it?
Potentially, my lady. I mean, lots of claimants who could have afforded to hire cars use credit hire. I mean, the authorities are replete with, and we've looked at some of them this morning, of claimants who could have afforded perfectly well, like Mr. Vent, to pay for a car over the counter in the usual way, who still used credit hire. So a defendant receiving a credit hire claim is entitled to know whether the person putting forward that claim is going to say, I'm impecunious or I'm not impecunious. It may be that in response to any credit hire claim where nothing is said, the defendant has to say, well, are you impecunious or not? And the claimant can then come back and say, well, actually, I am. But I would respectfully say that's a rather artificial process in the vast majority of these claims.
Right, so now you're going to move on.
So I will now, my lord, move on to what happened in this case. And I was actually going to start with our letter of the 4th of June 2019, which is in the supplemental appeal bundle at page 47. Three separate points were taken in response to the claim. The first point taken under the heading of rate is that the claimant has not proven impecuniosity, therefore only entitled to recover the lowest reasonable rate quoted by a mainstream supplier. Now that is the classic, we're not liable for the difference between credit hire charges and basic hire charges answer. There is then this heading intervention, which did occupy a good deal of the court's consideration in both of the hearings below and is not an issue for this court. And I propose to say very little about it, but just so that the court can understand what the issue is here. In certain circumstances, if the defendant, or the insurer, offers the claimant the use of a vehicle while their own is off the road, depending on the terms of that offer, it may be unreasonable for the claimant to reject it and get a vehicle elsewhere. And in this case, it was held that the defendant had not done enough to make good that argument, and so I need to say nothing more about it. And then over the page at page 48, under the heading of need, this is what sets up what I would call the Hussein issue, although Hussein on appeal hadn't actually been decided when this letter was written. There's no mention of Hussein as a case. What there is a clear raising of the issue which Hussein is concerned with. So it says the claimant is asked to confirm in evidence whether they had any alternative vehicles available and why this could not be used instead of hiring a vehicle. And then the claimant is asked to evidence full and complete financial accounts to demonstrate that their daily profit was higher than the daily rate charged, and therefore why hiring a vehicle was more appropriate than pursuing a loss of profit claim. Now, I don't think it's ever been an issue in these proceedings, certainly no issue was taken below, that was enough to put in issue what might be called the Hussein point. And certainly I submit, bearing in mind that these are documents which are written by insurers, they're not written by qualified lawyers. The point is squarely taken there that it's for the claimant to justify making a claim for vehicle hire charges which may well have exceeded the lost profit.
But that's part of the Hussein point, isn't it? It's not. Impecuniosity is only raised in the context of the BHR point, the first point in the case, which you agree is moot because there was no evidence about the BHR in this case.
Yes. We do not pursue this as a BHR, as an ordinary BHR comparison claim. But Hussein isn't just about impecuniosity, it's about aggravation of loss generally. So the essence of Hussein is the measure of loss for the loss of use of a profit-earning chattel is your lost profit. If you're going to claim more than that by way of hire charges, it's for the claimant to justify that decision, which isn't just on the grounds of impecuniosity, because Mr. Justice Pepperell identified 3 situations in which the claimant might have justified doing so, one of which was, for example, not wanting to lose an important customer. So all the defendant in my submission has to do is say, you need to show why hiring a vehicle, to use this language, was more appropriate than pursuing a loss of profit claim. In other words, show that you have not failed to mitigate your loss. Now, this letter actually followed the certainly the date on the claimant's witness statement, from which it was clear anyway that he was relying on impecuniosity as the reason for hiring the vehicle. And that witness statement is behind tab 6 in the same bundle. And only 2 paragraphs in this witness statement addressed impecuniosity. Paragraph 6, first of all, and we can see what it says there. And then over the page, paragraph 12.
You said tab 6, is it?
Tab 6 of the same bundle, the supplementary bundle.
Mr. Poole.
I hope. Page 55A. I may have the pages in a different order. Mine.
Yeah, it's tab 5, the back of tab 5.
That's just the way I filed it.
It is
Sorry, my
tab
lord.
5. Yeah.
So yes, it's page 55A, paragraph 6, and then over the
That
page,
makes more sense.
paragraph 12. So there's no doubt that this was the issue and the basis on which the credit hire charges were justified. The issue of impecuniosity was, I submit, put in play before the Deputy District Judge who dealt with the first hearing. A large part of what is said against me as to the scope of this appeal is, I think, that effectively all the focus was on intervention and impecuniosity was abandoned. And in my submission, that's clearly not the case. And in judging the actions of the parties in these sorts of hearings, in my submission, account does have to be taken of the fact that these are very short hearings in which there is very little time to get one's points across. But it was sufficiently got across. And we have the transcript of the first instance hearing in the supplementary bundle behind tab 1. And the relevant parts of this in my submission are, first of all, at the bottom of page 2, we have the claimant's counsel, Mr. Seed, first of all taking the court to the 4th of June letter. So there's no doubt that the court was aware of the letter and had been shown it. We then have, in the middle of the Defendant's Counsel's submissions, on page 5, a clear in my submission reference to impecuniosity and also the particular mitigation issues that are raised by Hussein. So if we look at that page, there are unfortunately no line numbers, but if one counts down 6 lines from the top, there's a sentence that begins, if you take those figures, then the claim at £389.49 a day, and so on. So what counsel is doing here is calculating what these higher charges amount to effectively as an annual income, and then he goes on. The whole point of my putting those figures is that would not be a reasonable mitigation of loss, because this is alleged to be an impecunious taxi driver who cannot possibly be something inaudible £3,000. So if that was the question, it would be inappropriate, and it looks as if he meant to say appropriate, for him to pursue a loss of earnings claim, not such an expensive and large claim for an alternative vehicle. So it's firmly put in issue there, I submit. And then he goes on in the second half of the following paragraph. It is pointed out under rate that impecuniosity is not proven. The efforts to deal with that merely constitute the statement that you have from the claimant. It says in paragraph 6 he does not have the means. He provides none of the other financial information on which any of those matters could be put forward. And now, that in my submission plainly and certainly sufficiently for the purposes of a hearing like this, put the issue before court. And indeed, the Claimant's Counsel responds to it at the top of page 7, albeit very briefly. He says there, it is an interesting argument that my learned friend does not then advance with relation to earnings, and he should have just sat on his backside and not gone out and earned a living, which something a measure of damages my learned friend is not something. It's perhaps slightly cryptic, but what it's clearly getting at is that it's not reasonable for the defendant to say that this claimant should have sat at home not earning. So there is engagement there, I submit, with the point that has been raised. Now, there's no dispute, and so I don't need to take the court to the judgment of the deputy.
Sorry to interrupt you, Mr. Armstrong. Is the Claimant's Counsel making a slightly different but related point in the last paragraph of that part of his argument? Defendants cannot then shuffle back to say, oh, well, it's stage 3 when you've got the burden of proof. The usual standards of expected claims doesn't apply to us, and unfortunately, that's exactly what the defence are doing here. It's a little bit difficult to understand what point that's directed to.
It is. It may have been the intervention.
To the impecuniosity point?
It may have been intervention. Certainly, the Claimant's Counsel doesn't address impecuniosity head on. And it's certainly fair to acknowledge that the bulk of the argument was directed at the intervention point. But all I have to satisfy the court of, I submit, is that the Defendant's Counsel sufficiently put the point in issue. Because what's being said against us today is, in essence, you abandoned impecuniosity. You may have raised it in your letter, but you never really pursued it, so you shouldn't be allowed to pursue it now.
Well, I think the way, let's look at Mr. Williams' skeleton, paragraph 2, the point was never in fact developed before the Deputy District Judge.
Yes.
It may be that he says somewhere else that it was abandoned, but certainly in that part he's saying, okay, it was there, but it wasn't what
yes.
the hearing was about.
Well, I mean, if that's how it's put, if it's a question of how much is said, then in my submission that shouldn't be the right test in what is, as I've said, a very short hearing, yes. When all you can do is get out your points as fast as you can, and the point has been made. And in many ways, my answer to this anyway is the fact that with the claimant's consent, all of this was dealt with in the first appeal below. But if I do have to show the court that it was put in issue, I do submit that that was enough to put it in issue. And to say any more is required is really to hold advocates in these sorts of claims to an impossible standard. The district judge, deputy district judge, did not then deal with this in his judgment. There's no dispute about that, and there's no point going to the judgment to show what isn't there. What matters after that is what then happened on the first appeal. We have the grounds of appeal in the core bundle at tab 9, page 96. And grounds 1, 2, and 3 to a large extent reflect the structure of the 4th of June 2019 letter. Point 1 is effectively, although it encompasses, it could be said to encompass both the BHR argument and also Hussein argument. It's effectively a BHR argument, but in any event, it's a question of whether the claimant was reasonably mitigated. 2 is then the intervention point, and 3 expressly raises impecuniosity. And those points were developed in the skeleton argument, and in particular what I would show the court is under ground 1. This was actually treated as principally a Hussein argument, so we see that tab 8 of the same bundle, page 78. We see the argument set out at 5.1 to 5.5. And in particular at 5.5 that it was incumbent upon the claimant to provide details in his witness statement, and that the claimant had failed to do that. And then impecuniosity is picked up again at paragraph 7.1, at page 82 going on to 83. There's just a sentence at the end of that paragraph: no financial evidence was given in respect of impecuniosity to justify a claim for credit hire. Now, it's relevant at this point to show the court the respondent skeleton argument in response, because it's actually the respondent who first puts the question of transfer out under paragraph 7.2 in issue. And that is, I think, behind the same tab at page 85A.
Yes.
And it's in paragraph 1, at the bottom of that page, where the submission is made, whilst the court must, of course, apply proper judicial scrutiny to that which is before it at a stage 3 hearing, it is always open to a party wishing to challenge evidence more substantively to exit a claim from the portal process and proceed as a Part 7 claim. Parties must consider whether the benefit of proceeding as a Part 7 claim outweighs the more generous cost provision which applies if the claim no longer proceeds within the portal. There was then at paragraph 5, we see an attempt, which was also repeated in the appeal hearing itself, to put forward an argument that actually the district judge hadn't failed to deal with impecuniosity. What he must have done was implicitly have accepted the claimant's evidence. And so an attempt is made in paragraph 5 to argue that actually the court accepted the evidence of need from the witness statement. And then paragraphs 10 to 11 expressly address the Hussein argument, at 85D going on to 85E. And there's an important concession in this, in paragraph 10, where it was said, it is probably reasonable to assume, in the absence of any other evidence, that the daily profit of a private hire driver would fall below the 347.39 daily cost of hire. That's quite an important concession, because that is firmly putting the onus onto the claimant then to justify the claim for the difference. And then what's said in paragraph 11 is it's all fine because the claimant is impecunious and therefore he falls within the third exception in Hussein. So that is where the battle lines were drawn on the skeletons before the hearing. And at the outset of the hearing, and I need to take the court to the transcript of that next, which is Supplementary Bundle Tab 2. The learned circuit judge below was alive to the question of exactly what points there was and wasn't permission to appeal on, because the Deputy District Judge had given permission at the end of his judgment. I'm sorry, my lord. Her Honour, Judge Sykes, yes. But the Deputy District Judge had at the end of his judgment given permission to appeal, but arguably only on the intervention point that he had given judgment on. But there had been a further grant of permission to appeal by His Honour Judge Gregory. And what Her Honour Judge Sykes wanted to do at the beginning of the hearing was establish whether there was any issue as to what it was open to the defendant to argue. And so we see that at pages 10 to 11 of the bundle. I'll just try and give the court the broad directions as to where to find these points. So we see in the middle of the page the judge referring to Copley, that's the intervention point, and then the additional permission to appeal given by Judge Gregory on paper. And then at the bottom of that page, it may not be taken in issue by Mr. Harthen, but because it is a slight irregularity, I just wanted to clarify what everybody believes to be the position in terms of the permission to appeal, because there was already permission from the lower court. And then Mr. Harthen is asked, are you going to take a point on this at the bottom of page 11? And he says, I was not intending to take that point. It seems to me that the issues are, was there a failure to mitigate? Specifically, should the district judge have found that the claimant should have made a loss of earnings claim, or should he have found that he should have accepted the offer in the Copley expansion letter? So clearly identifying the two key issues as being the Hussein argument and the intervention argument, both of which he was very happy to deal with. And he did. And as I said earlier, he attempted to maintain the submission on the appeal that actually the Deputy District Judge hadn't failed to deal with impecuniosity, but really should be taken to have accepted the claimant's evidence. And we see that at page 40, that's bundle page 40. And we see, first of all, at the top of the page, the end of something said by Mr. Harthen for the claimant, noting that Hussein is the governing authority. And then he's asked in terms, what do you say about the fact that the Deputy District Judge didn't deal with it? A little further down, he says there are no express words in the judgment, but he says it's implicit. And there's essentially agreement that it wasn't dealt with. Now, I am taken to task for saying in our skeleton argument that it was common ground that the district judge should have dealt with it. I accept that that is not said in terms, but when Mr. Harthen is being asked these questions, what he doesn't say is, well, there was no need for the district judge to deal with it because it wasn't a live point before him. That clearly wasn't his position. It's then, before we leave this, the other relevant point to look at is how the question of transfer out into Part 7 arose. And it was actually raised by counsel for the defendant at page 37 of the bundle. And in the bottom paragraph on that page, the defendant's counsel responds to the suggestion of whether it could have gone out into Part 7. He says the question of whether this should have gone to a Part 7 claim is again put into the hands of the defendant. I just draw your attention to the fact that the relevant practice direction, which is 8b, provides that para 4.1, I think that is meant to be a reference to 7.2, that it could have been an application of either party, or it could, although it is not done in all, it could have been transferred to Part 7 at the court's permission if it thought the matter was too complex to deal with as a Stage 3 claim. I think that's all I need to show the court in terms of the transcript, and then I can deal very quickly, and I hope to wrap all of this up before 1 o'clock, with the judgment, which is tab 7 of the core bundle. And at page 66, which is the first substantive page of the judgment, we see, first of all, recorded in paragraph 4 that the claimant's counsel accepted that the defendant had permission to pursue all 3 grounds of appeal. At paragraph 7, we see the reference to the White Book commentary on Phillips and Willis and the need transfer out only in rare and exceptional cases. We see at paragraph 15 at page 67, identification of the issue of impecuniosity and loss of profit, and the defendant saying there just wasn't enough evidence before the Deputy District Judge to satisfy the requirement. Then at paragraph 22, and really it's 22, 23 and 24 and then 25 are the nub of the decision. And actually what the learned judge did was consider transfer out first and then the question of whether the evidence was adequate. And one should be careful in my submission of not overly anatomizing the aspects of this decision, because the decision-making process appears to have been, you can't take this out into Part 7. That's the first conclusion reached in paragraph 22. On the authority of Phillips and Willis, this is not one of those rare and exceptional cases which should be transferred to Part 7. So that's stage 1 really in the decision. It follows you're stuck in the protocol, and in the protocol we have to do the best we can. And so paragraphs 23 and 24 amount to, in the restricted, quick and proportionate procedure that we are obliged to work within, the evidence was adequate and therefore satisfied the third exception in Hussein, and therefore that ground was not made out. It was not a requirement the Deputy District Judge had to make. That's the essence of the decision. We have to stay within the protocol, and given how we operate in the protocol, I'm going to accept this evidence as sufficient.
But the reason you have to stay in the protocol is because nobody's asking for the claim to be transferred out.
Certainly no one had made an express request.
Surely that's just the background. So the judge is saying, well, the background is we're in the protocol. But what's wrong with that? Because it wasn't an issue.
Well, my lady, what I say about that is that she has evidently considered whether to take it out. She could have said, well, no one's asked me to take it out, so I'm just going to deal with it as it is.
Well, why do you say that?
Because there would be no reason for the second sentence of paragraph 22 if it hadn't been material to the way she was going to deal with it. So what she's really finding is we have to work in the environment in which we are. We have no choice. I can't send this out into Part 7. She doesn't say, of course, whether she would have done otherwise, but she certainly makes a finding that she can't or that she shouldn't. That is a decision that she makes. She says this would not be one of those rare and exceptional cases. Now, it would have been open to her because
she doesn't make a decision because she hasn't been asked to make a decision. She just observes that, I've looked at that and I don't think this is one of those cases.
And it's a lead-in to 23 when she's identifying the restricted, quick and proportionate procedure on which she's then operating.
Well, I submit, my lady, it's a power which she had. It's a power which, as is worded, and in this respect, in my submission, the commentary in the White Book is accurate to say it's a power the court can invoke of its own motion. And had she not been misled by the commentary, and had she thought it might have been open to her to do so, it would have been open to her to make that decision.
But to get the ground of appeal off the ground, wouldn't you have to submit that this is a case in which the only rational decision for a judge would have been to exercise the power of her own motion and transfer the case out. Because if that's not the position, I just don't understand how this ground of appeal arises.
Well, my lady, if we approach it in terms of a discretion, the discretion was clearly, in my respectful submission, exercised wrongly because the learned judge was misled by that commentary as to what Phillips and Willis actually says. What that would lead to is that this court would have to make the decision for itself or consider whether that would be an appropriate way of dealing with matters now. I don't have to persuade the court, I would respectfully submit, that it's the only rational response.
Well, wait a minute. So let me just I just want to understand this submission. So you submit she exercised discretion wrongly because she was misled by the White Book commentary. But why does the discretion arise to be exercised on these facts if neither side is asking her to do it? That's really what I'm trying to get at. Surely the submission only gets off the ground if it was so glaringly obvious that the case had to be transferred out that the court was obliged to raise the point with the parties of its own motion.
Well, my lady, if we take as the premise that it's a power that the court can exercise of its own motion, if I can assume for the moment that is a correct submission to make, had she not considered the issue at all, I accept that I would be in difficulty. But she did consider it, but considered it on a flawed basis. So there was a decision that was made, and that decision was wrong. Had she said nothing at all, the position might be different. But she clearly actively considered whether it was a case that should be transferred to Part 7. And it may well be, and there's always a danger, of course, of trying to read between the lines of a judgment, it may be that she was troubled by the fact that she was being asked to decide this based just on very thin evidence, but felt constrained to decide what she did, in part because it was a case that had to remain within the protocol. It's part of her decision.
Can I ask you this question? I mean, would it be a lawful exercise of this discretion for a judge to make a decision on the point without asking the parties for their submissions?
Potentially, yes. Yes, I would say that, my lady,
Because
it's a power of...
As you've been explaining to us, there are extensive cost consequences for the parties if the claim is transferred out. So you're saying it would nonetheless be lawful for the judge to consider exercising the discretion to exercise it without asking for the parties' submissions?
The power can be exercised by the court of its own motion. I mean,
Yes.
Phillips and Willis was not decided simply because it was a decision of the court's own motion. It was decided on the basis that it was a decision of the court's own motion which shouldn't have been made.
Mr. Carpenter, I'm not disputing that, of course, the court can exercise the discretion of its own motion. I'm asking you to deal with a different point, which is whether it would be lawful for the court to exercise this discretion of its own motion without asking for the parties' submissions on it.
Well, the correct analysis may be that it's like other decisions the court makes of its own motion, that obviously the parties have to have the right to come back before the court if they disagree with what the court has done. But of course, where the parties are before the court, it would have been open to the judge, for example, to say, actually, I'm thinking of transferring this out into Part 7. Does anybody want to persuade me that I shouldn't do that?
Well, sorry, it would have been open to the judge, or she would have been obliged to ask the parties?
Well, if the parties are before her and it's in the course of a hearing, then that would be the obvious thing to do, would be to ask the parties for their positions. But in terms of the general operation of the rule, as it's drafted, it is something which it would be open to a judge picking up a case, looking at it and thinking this is just not suitable for a Stage 3 hearing, to exercise the power and transfer it out.
Yes, but we're not dealing with an abstract case where the judge is looking at the papers. As you've accepted, we're dealing with a hearing. What I'm trying to ask you to focus on is the question whether the judge could lawfully exercise his discretion when the parties are before her without asking for their submissions. And I just want to be clear whether you're saying she could lawfully have exercised the power without asking for submissions or not.
If she doesn't ask for submissions there and then decides in the judgment that she's going to transfer it out, then if anybody didn't want it transferred out, they might be able to mount an appeal on that basis. I mean, the issue of transfer out emerged, albeit only briefly, in the argument before her. But if, having gone away and thought about it, she thought the only way to do justice, this is a reserved judgment, if having gone away and thought about it, she thought the only way to do justice would be to transfer it out, then I would submit it would have been open to her to do that.
Right. All right. Well, I hear what you're saying.
Now, clearly, we've asked you questions and we've got to 1 o'clock and you've got a bit more to do. So shall we take a break now and come back at 2 o'clock, hopefully warming up in the process of the hour. Thank you.
Thank you.
2 o'clock.